Kristen Huerta.
Let's call her. Is she on probation? Is she a probation case?
No, Your Honor. She's it's control, but there's a motion to revoke or modify bond.
Okay. We're on the record in both 2022 CR 458 and 2024 CR 524, each caption State of Kansas versus Kristen Nicole Huerta. Please announce appearances.
Jared Regier on behalf of the state.
Joshua Andrews on behalf of Kristen Huerta, who is also present for the Zoom call.
And how does she want to proceed, Mr. Andrews?
Your Honor, with regard to the status of control settings, Ms. Huerta has been determined to be incompetent to stand trial and was ordered to undergo competency restoration. She was in custody at the last hearing and subsequently bonded out. I would defer to Mr. Regier as far as if he has an update on where she is at on the waiting list for Larned State Hospital. But in the meantime, I did send an email to the person who conducted the competency evaluation with South Central Mental Health to determine whether we could arrange for outpatient competency restoration. But I did not receive a response. So I would want to follow up on that if it still looks like it's going to be some period of time before Larned State Hospital was an available option for competency restoration.
Mr. Regier, have you any information on the competency?
Unfortunately, Your Honor, I have not had the opportunity to review that matter further. Certainly, I am prepared to do so. For purposes of this hearing, the state's primary concern is the motion that was filed by my office earlier this month on August 5th.
Mr. Andrews, were you gonna explain to them that there's no way
Kristen,
that I could not?
Kristen, yes,
Okay.
we'll get to that. Just go ahead and mute yourself, okay?
Okay.
Did you file the motion that you referenced, Mr. Regier?
Your Honor, the electronically filed stamp date in my record appears to be August 5th.
Motion revoking bond. That is your concern today?
That would be the state's primary concern at this juncture, Your Honor.
And the basis of that bond appears to be that she continues to violate protection orders.
That would appear to be an accurate summation of the motion allegations in the motion, Your Honor.
And we took some of this up last time that are her parents here again this time?
I see Melanie Penrod, who is her mother, and and I also see Doug Penrod, who is her father. It looks like the motion alleged that she had contact with Melanie Penrod, who is an endorsed witness in one of the cases. And I think that we had mentioned the difficulty with that is that Ms. Penrod is Ms. Huerta's guardian and conservator and payee. So they're not, it really creates an impossibility with her being out of custody to not have contact with Ms. Penrod, because that's who she needs to contact in order to get money on her card or for day-to-day issues, since she has been determined to lack capacity to manage those affairs on her own, which is why she's under a guardianship. So we would be orally moving to modify that bond to allow contact with Melanie Penrod, despite her being an endorsed witness, because it's just really an impossibility for her not to have contact.
Ms. Penrod, what is your response to that?
My response to that, Your Honor, is, and I do believe in one of the hearings you told her that since I am her guardian, when she does communicate with me, she is to be civil. But she's not supposed to come to my house. And that was decided long time ago by Judge White in Andover in one of the cases, the Andover cases. And she showed up at my house after she got out of jail. And I even told her prior from her leaving to come here, I said, Kristen, you cannot be here. You know that. just have a friend come get your debit card because she was needing her debit card. She just got out of jail. So that would be my concern on that. Another cause that I would consider a revocation of bond is a few days after she got out of Butler County on this case, she had interaction with the police and did not report it to her bondsman, and was taken into Wichita on a bench warrant. She is still doing meth extremely bad. And of course, when she does, she harasses me. So, I mean, I agree, Mr. Andrews, that there has to be some type of, leverage there as far as communication, being I am her guardian, but it does not need to entail harassment in calling 40, 50 times, blasting on text, calling me names. That is not necessary as far as communication between a guardian and a ward of the court.
Would you raise your right hand, please?
May
Ms.
I
Penrod?
interject?
Yeah, Ms. Penrod, please raise your right hand. You solemnly swear the testimony you're giving today is the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right, you may lower your hand now. You are Melanie Penrod, and as I recall, you're the stepmother of the defendant, Kristen Huerta, is that correct?
No,
Your
I'm her
mother?
biological. I'm her
All right.
biological mother.
Okay, and is Doug Penrod your husband?
He is my husband and her biological father, yes.
Okay. And everything you've said so far today, is that the truth?
And Your Honor, I'm going to object to many of her comments as being hearsay, lacking foundation. When it was prior to testimony, I wasn't going to object because it didn't have any evidentiary value. But since she's been sworn under oath, I would object to most of what she had to say as lacking foundation and/or hearsay.
Well, I'm not sure that I remember a lot of inadmissible hearsay, but Ms. Penrod, would you tell us again, just go over your statement? I was just going to ask you if everything you said was true, but he's objecting to some of that as inadmissible hearsay. So could you go over that again?
Would I do what again, Your Honor?
Would you go over what you've told us again? I'm sorry to make you do that, but I want that to be a record of evidence.
Okay, from the very beginning.
Right, what has she been doing in violation of law, if anything?
When she got out of jail, she needed her debit card. Let me adjust. I'm sorry. I apologize for that. And she called me and said she was going to come get it. And I told her, no, Kristen, you're not. You're not supposed to be here, and you know that. She ended up coming over anyway. Let's see, there was that I had said. I also said that she had.
Excuse me, you had her debit card. Why?
I am her payee rep.
For her what? Social Security disability or
For
what?
Social Security, yes, SSDI, Your Honor. And I control her finances, and I have a debit card, a green light card where I can control her spending.
And you're appointed by the court to do that?
I'm sorry?
Are you appointed by a court to do that, to control
I
it?
am appointed by the Social Security Administration to do that.
Very well, go on.
Let me think of where I was at. Oh, she also, as I stated, she had been taken to court.
Objection, Your Honor. Foundation for the witness's knowledge as to this information.
Tell us how you know she was taken to court.
Okay, I misspoke on that. When she got out of jail with you guys, she was picked up on a bench warrant and taken to Sedgwick County and did not notify
Objection, Your Honor.
her.
Foundation.
Just tell us how you know that. How do you know she was picked up? Did she tell you? Did you see it? How do you know?
One, she told me. Two, the manager of the hotel where she's staying at told me.
Objection, Your Honor. Hearsay.
Oh, sustained.
Your Honor, it's not hearsay. She told me personally. It's also in, I mean, if you were to look up.
Sustained is to the third party, but not to the defendant.
Pardon?
I said, I'm gonna only sustain it to the hotel manager because he's not here. She is here, so go ahead.
Okay. Yeah, because she told me. Because she had a bench warrant with Sedgwick County, and she did not show up for that because she was incarcerated in Butler County. Was there something else, Mr. Andrews, that I'm missing here?
All right. Thank you, Ms. Penrod. Doug Penrod, is there anything you want to say on this matter of bond?
Yeah, she admitted to my wife that she was.
Raise your right
That she
hand.
spoke.
Sir, raise your right hand. You solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
All right, you may lower your hand now. What were you're her father, right?
Yes, I am.
And you and Mrs. Penrod have been victims of threats and phone harassment and different crimes over the course of years.
Yes.
All right, what do you want to say on this instance?
She had admitted to smoking meth since she's been out. So, I mean, to me, that's kind of a violation, but
Mm-hmm. And you said that, she told her mother she picked up on a warrant. What do you know about that? Did you hear her tell her mother?
no, my wife told me.
All right. Any questions from either party?
One moment, Your Honor. Your Honor, if the state may ask a couple of brief questions to the witness, Melanie Penrod.
All right, Ms. Penrod, you're still under oath.
Yes, Mr. Regier.
Is it still your testimony that the defendant had contact with you both by phone and in person at your residence?
Yes.
Okay.
Yeah.
On what date did those contacts occur?
The dates. I do not have the dates in front of me, and I apologize for that because I have a neurological issue and I do not remember the dates properly. The first time she just came over to our house, walked in the house when Mr. Penrod was at home, and there was a PFA against him with Kristen, and she came over and just walked in the house, and Doug was there. So that is a violation of PFA, in my opinion, a reason for revocation.
That happened back in November whenever my daughter was first born. So I'm understanding not as to why that was not
Honor,
previously reported. Because
Stop a minute. Okay, Miss Melanie Penrod was talking. Miss Huerta, you'll have a chance to talk with your attorney and present evidence if you wish. Let's let Miss Penrod finish without interrupting Miss Huerta. You can add what you want to later. Go ahead.
Okay. There was a PFA in play at the time that she came over and just walked in the house, in the dining room. So she did violate that PFA against Mr. Penrod. The last time she came over here, when I told her not to, because you can be a guardian from afar, and that's the only way her and I can do it. I told her not to come over, and she still did. That Mr. Penrod went up to Andover Police Department and filed a case, and I do believe that he sent it to Jacqueline Green.
Okay. And this this last contact that you've referred to, do you recall approximately how was that within the last week, month? How long ago?
That was, it was within a few days of her getting out, being bonded out this last time with you guys, Butler County Jail.
Okay. All right, and a redirect, no further questions, Your Honor.
Okay, any other questions from any attorneys?
No, Your Honor.
Okay. All right, any questions for Mr. Penrod?
Just very briefly, Your Honor.
Go ahead.
Mr. Penrod, were you aware of in-person contact between the defendant and the witness, Melanie Penrod, at your residence?
Yes, I was.
Okay. Do you recall exactly when this particular contact took place?
I could go through my emails and tell you the exact date, because I sent Jackie I think I sent Jackie a notice that she had been at my house.
Your Honor, if the witness may do so for the purpose of refreshing their recollection.
That'd be fine. And would someone please explain or remind me who Jenny Green is? I'm hearing someone I don't recognize.
Your
Jennifer
Honor,
Green?
the state understands that is the on-staff victim witness coordinator.
Okay, thank you. That'd be for the county attorney's office.
That would be the state's understanding, Your Honor.
Thank you.
I believe it was roughly 3 weeks ago.
Did she make her bond before or after this contact that you're trying to pin down?
She was bonded out. Donnie Kirkman is her bondsman, and it was probably 4 to 5 days after she had bonded out that she showed up at the house. It was about 10:30 in the morning.
And Mr. Penrod, after you became aware of this contact, did you take any actions?
I called Andover PD.
Okay. And was it just a phone contact, or did you take any further actions with law enforcement?
No, I went in there and filed a report after work.
Okay. And is it your testimony that after this contact occurred following appearance bond being successfully made in this case, it was between that time, the contact, and thereafter that you filed this police report?
Yes.
Okay. All right, and a redirect, no further questions, Your Honor.
Questions?
No questions, Your Honor.
All right. Any further evidence, Mr. Regier?
None from the state, Your Honor.
Okay. From the defense, Mr. Andrews? Does your
No.
client wish to testify?
No, Your Honor. I think I can make argument based on the evidence that has been submitted that through the testimony, I can put that into context, but my client's independent testimony is not necessary.
All right. Well, Mr. Regier, it's your motion. Do you want to make argument?
Yes, Your Honor. As stated in the motion, this is a case where the defendant is charged by way of information with one count of violation of a protective order. The second pair of the motion refers to a professional surety bond that was executed on July 28th of this year, listing all standard conditions, including that the defendant, quote, will not have contact with a witness or alleged victims directly or indirectly, based off of the testimony of the two witnesses. The state does respectfully submit to the court that that condition of the defendant's bond has been violated. Therefore, the state is moving to revoke or modify the bond as the court deems appropriate, notwithstanding any pre-existing relationships, legal or otherwise, that may exist. I believe the state respectfully submits that the court's orders concerning the conditions of the bond are quite clear, and the state does respectfully submit that those orders have been violated.
And the order of that July bond, did you give the specific date?
Yes, Your Honor. The July bond does appear to be executed on July 28th of this year for an appearance on today's date and time. And it does list the standard conditions of bond, including that, quote, the defendant will not intimidate nor have contact with a witness or alleged victims directly or indirectly. And the state would also note that pursuant to the information filed in this case, besides listing both witnesses in count 1 of the charging language, both those individuals do appear to be listed as endorsed witnesses on page 2 of the same.
Excuse me, Your Honor. July 30th is when she showed up on my house.
All right, thank you. Mr. Regier, anything further?
Not from the state, Your Honor.
Mr. Andrews?
Thank you. Yeah, thank you, Your Honor. We would concede the appearance bond does specifically state no under the pre-typed standard conditions, no contact with witnesses. It does not specifically name Melanie Penrod, and in the past, Ms. Penrod has not been an endorsed witness on the cases that have been involving Doug Penrod. Frankly, I myself didn't catch the fact that she was endorsed in this newest case because in the past it's always been kind of a situation where Ms. Huerta has had to have contact with Ms. Penrod because of the nature of the guardianship and conservatorship and payee.
I'm in court right now. Hold on.
Kristen, can you please mute yourself?
Oh, yeah, I'm sorry. I thought I had it muted.
Sorry. This is a situation where Ms. Huerta was released from custody. She did not have any way of utilizing the funds that have been allocated to her by the government through the Social Security. Those funds were being held on a debit card that was in Ms. Penrod's possession. She had needed those funds, and the only way to access them was having contact and retrieving them from Ms. Penrod. The situation, frankly, would probably best be served if a different person was appointed as the guardian and conservator and the payee, so that we didn't have the situation of trying to have contact without having contact, threading a needle of what is or is not a violation of the prior protective or no contact orders. But that's outside the purview of this case, unfortunately. And so at this point, I am requesting that instead of her bond being revoked, that her bond is modified to allow contact with Ms. Penrod for as long as she is the guardian and conservator and alternate payee. If at some point that changes and she's no longer serving in that capacity, then I think that it would be not a problem at all for there to be a no contact language in there. But until such a time, it's creating a situation where Ms. Huerta is being set up for failure through the legal requirements that she's placed under by other courts and other government agencies. Again, Ms. Huerta has been determined to lack capacity to manage her own affairs, and it's been determined that Ms. Penrod has to manage those affairs for her, and that the only way Ms. Huerta can function is by having that contact. And so we would ask the court to modify that bond condition to allow contact with Ms. Penrod only, and that this matter be set over to try to ascertain the status of the competency restoration.
Well, we took into consideration the financial arrangements between Ms. Penrod and Ms. Huerta previously, and I agree that someone else in that position, it might work better because of the hostility between the daughter and the mother. However, I have not told her she couldn't have contact as much as I've told her it has to be peaceful contact, if I'm remembering correctly. So there's no reason why she couldn't have contact with her mother or payee and do it peacefully.
And that's fine, Your Honor, if that language could be, specified in the order modifying bond that Ms. Huerta is allowed to have peaceful contact with Ms. Penrod regarding her duties for as long as Ms. Penrod is serving in that capacity.
Well, my concern now is that she just can't bring herself to be peaceful with her mother.
Your Honor, I would submit that there's no evidence before the court that the contact was not peaceful. The complaint is that she went to the house to retrieve the debit card, and Ms. Penrod didn't want her coming to the house to retrieve the debit card. She wanted her to figure out some other way of getting the debit card to her. But in the meantime, Ms. Huerta didn't have access to the funds that she needed.
Did I misunderstand you, Miss Penrod? Was it a peaceful contact?
No, she was all messed up. When I told her not to come over, her friend that she was with said that he would come over and get it. That way Kristen wouldn't have to come. And I told Kristen not to come. I mean, specifically, do not come over. And I think the court is kind of pushing aside the fact that she walked in our house when Mr. Penrod was here, when there was an active PFA against him.
My understanding is that was an incident that happened in November prior to any of this being an issue, Your Honor. I just don't think that's relevant to the proceedings as far as the motion to revoke or modify bond.
It is relevant because it happened. I mean, the PFA was already in effect, Mr.
Right.
Andrews.
But that, Your Honor, and again, I would just say that the issue here is whether Ms. Huerta violated her appearance bond. There was no appearance bond in November when this alleged incident happened. And further, that it's not really relevant to the question of whether peaceful contact can take place going forward.
Okay.
Is it possible there might be someone else that can step in this role of payee for you?
I am in the process of doing that, but the problem is the harassment will not stop because
What harassment?
that's just the way that Kristen is towards me and has been towards me since she was a teenager. Once again, I am going to reiterate, Your Honor, because I do believe that it is pertinent to the facts of the case that the PFA was in order prior to her coming over and walking in her house. And walking in, in our house. I mean, she violated the order with Mr. Penrod.
And the PFA says she's not to have contact with you and Mr. Penrod. Is that what the PFA says? Or does it say Mr. Penrod is not to have contact with her?
The PFA, Doug?
I believe the PFA says that she's not supposed to have contact with me or my wife. And forgive me, because I'm kind of a straightforward guy. We can put all this no contact stuff aside because there are other violations that she did as far as smoking meth, getting.
Your Honor, I'm going to object. None of these other alleged violations were contained in a motion. There was no notice given of any alleged violations. No evidence has been provided other than essentially some uncorroborated statements. I think that that is irrelevant to the question of whether she violated the motion or violated the bond condition. And frankly, we don't disagree that technically the bond violation or the bond condition was violated by her having contact with an endorsed witness on July 30th. We are simply asking the court to modify that bond condition to allow the contact based on the necessity created by the guardianship and conservatorship and alternate payee status.
And that status still could have been met without her coming to the house personally.
All right, Mr. Regier, is there anything else you want to say?
Not at this time, Your Honor. The state does stand by its motion, and the state would request that the motion be granted in this matter.
Do you have any idea how far on the list she is to getting into the state security hospital? And she was ordered on July 14th, I believe it was, of 25.
One moment, Your Honor.
And Your Honor, I think it was earlier than July 14th, but I may be mistaken on that. Yeah, it was April 14th that she was ordered to undergo competency restoration proceedings.
Yes.
And Your Honor, the state's information is that at least as of approximately 1 month ago, she was 20th on the list in response to the court's inquiry.
Is she getting any local mental health?
My mom has to fill out the paperwork for MHA because since I was in jail for the 6-month period, they deactivated my status as an active client. So my mom has to apply for my active client status with them.
That is true. I am waiting on the social worker to send me the paperwork, and they still have not done that.
But I was just gonna ask whenever I have a second to speak, if you'll let me. So I was gonna ask a question. I don't comprehend how it would be possible to have not had contact with her as far as going to get my card. She wanted to have just my friend go pick up the card, but there's no guarantee that if he would have picked up the card, which I know that he wouldn't have done this, but there is the possibility that he could have ran off with it and then it would have left me without any card. So I rode with him so that way I would be able to personally be able to grab the card. Otherwise, there's no guarantee because it's happened before where she's paid somebody rent money before for me instead of giving it to me to go pay the rent, and they ran off with $500 or $600, and then I was the one that was at fault for that. But she chose.
All right,
She
here's
chose.
what I'm going to order, folks. The bond has been violated. Now the question is, do I revoke the bond and have Ms. Huerta with her mental illness sit in jail while we wait for the state security hospital to get a bed for her? There's a pretty strong opinion that the jail is not suitable for the mentally ill.
Correct.
But at the same time, Ms. Huerta, I can't keep you out on bond if you're going to not take it seriously and abide by it.
I'm taking it seriously. I haven't violated it other than I went to go pick up my card. You know, that was something I had to have to be able to eat. I hadn't eaten that whole entire day and half of the day beforehand because I didn't have my finances. And so it's something, ma'am.
Please stop. So can I order that if you have to have contact with your mother, maybe you can do it through the local law enforcement, kind of like a child custody case? If you can exchange
Whatever
a card
you believe, ma'am, whatever you feel would be the best would be.
Well, let's see what
I
your
would
mom
accept
says.
the recommendations of, whatever you decide and determine and deem to be the
Okay,
best route for that.
Miss Penrod, what do you think about that? If she needs something, she can go through the law enforcement or through the attorneys for that matter. You don't have an attorney, but she could go through Mr. Andrews and he could go through Mr. Regier, who could call you, either through the attorneys or through the local law enforcement if you have to have contact. Kind of like when in a custody case with children when they go to treat them.
Right. I have absolutely no problem with that, Your Honor, as long as she's not calling me and harassing me like it hasn't stopped.
Well,
It's still
Mr.
going on.
Andrews, excuse me, Mr. Andrews, Mr. Aguirre, this isn't a criminal, civil case, but do you think that would work if she needed a card, she could go through the attorneys and the attorneys could just handle it for them? Would either of you object to that procedure?
Your Honor, I would ask if it would be possible to have it as either through counsel or through a civil standby arranged through law enforcement. The concern would be if there's a need on like a weekend or it's just a day that one of us is unavailable, that need would be going unmet for an unknown period of time, whereas a civil standby maybe could be arranged much quicker.
All right, Mr. Aguirre, are you okay with that? Do the attorneys or civil standby with officers?
Your Honor, if short of outright revocation, if the court is prepared to order some alternative arrangement, the state will defer to the court as to how it wishes to proceed.
All right, Ms. Huerta, I could just right now just order that you go to jail. You've already violated my order where I told you to be in the courthouse today. Why didn't you come to the courthouse like I told you to?
Ma'am, I was unable to obtain a ride there. The guy that said he was going to bring me wasn't able to make the journey all the way out there.
You
And Your
need
Honor,
to order.
was that a condition of the bond that she be here? Because the last time that she was in court for the court to order her to do anything, she was in custody and had not bonded out.
Somewhere I saw that in the notes a moment ago. Let me see if I can track that down where
Your
that
Honor,
was.
yeah, I believe I am in a position to address that issue if the court will permit me.
Sure, go ahead.
Your Honor, it would appear that previously this matter did come before the court on August 11th, at least insofar as 24 CR 524 is concerned, where the motion is filed. It would appear that that time the defendant failed to appear, but counsel for the defense did appear, and the matter was set over to today's date and time at the request of the defense, and that the defendant was ordered to appear in person based off my notes.
Oh,
Yes,
and
Wasn't ordered to.
Kristen, can you please mute yourself? I'll take care of it. Okay. Your Honor, Ms. Huerta did not receive notice of the hearing on August 11th, which is why she wasn't here. That was the case that the motion had been filed less than a week before that, and there was it had not been. I think it was sent return receipt requested or something, but there was no actual notice provided Ms. Huerta of that proceeding. I did not have in my notes that she had to appear in person, just that she had to appear. And so she would not have been notified, as there was no journal entry served on her, and she was not notified directly by the court to be in person. So I just confirmed that she was going to be here, and that was the extent of it. Since there was, when she bonded out, there was nothing in the appearance bond indicating she had to appear in person for today's hearing.
Well, it looks like from my notes, my docket notes of August 11th, 2025, I, as court, personally told her she had to appear at the courthouse today.
She was not here on August 11th for Your Honor to personally tell her that.
All right, well, then I told you to tell her that.
And again, I don't have any recollection of that, Your Honor, and I certainly didn't have that in my notes, and just that she had to be here, so that she was not informed by anyone that she needed to be here in person today.
If I may say something, Your Honor.
Last time, go ahead.
Okay, she knew she was supposed to be here because she remembered from when we set this hearing many months ago. She knew she was supposed to be here. She did have a ride. She told me last night she had a ride, and she had a ride today. So I don't know why she was not able to make it, but she's present in Zoom. But I just wanted to reiterate on that. So, but
I'm gonna
that's all
set
I
this
have.
motion over. I'm gonna set this motion over and see how she does for a month or two. What do we have in about a month to conclude this hearing, Jim?
The closest we have for this case would maybe be November 3rd.
November what, 7?
November 3rd.
3rd at 9. All right. Be back here at the courthouse November 3rd at 9 a.m., Miss Huerta. What did I just say? Repeat it back to me. And unmute
I'm
so
gonna
we
show
can,
up on November 3rd at 9 a.m.
where?
at the 128 West Pine. Is it West Pine?
It's not 128. Mr. Bauer, what is it? It's been so long I've forgotten. 121?
Your Honor, I believe it's 218 West Pine.
All right, anybody know for sure the courthouse address? Mr. Aguirre's 218 West Pine?
Your
One
Honor,
moment, Your Honor.
Jen knows.
it is 201 West Pine.
201 West Pine. Thank you, Jen. You're to be back here, Miss Huerta, at the courthouse in El Dorado, 201 West Pine. Repeat that back to me.
I'm gonna be there at 201 West Pine in El Dorado on the 13th or on the 3rd of November 2025
At 9 a.m., okay.
at sharp at 9. Okay.
We'll get to work on
And
your transportation today if you need to.
yeah, I'll work on getting the social worker to call my mom about the paperwork for MHA.
See, that's the way to do it. You stay away from your mom and dad. You go through somebody else like your social worker to get your payee stuff worked out.
Is
Okay.
Ms. Huerta, would she be allowed to, because I'm not sure if how much of an active involvement the social worker would have regarding payee stuff. Hopefully a lot, but is the court authorizing the civil standby if Ms. Huerta does need to obtain something from Ms. Penrod?
Yes, Miss Huerta, now listen to this too. You either call your attorney when you need something from your mom, or you call the officers, the local police, to go stand by the residence and wait while you interact with your mom, so we don't have any more rude, loud, angry conversations.
And-
Ma'am, yes. Is it possible to request that she keep a certain amount every day for food and other necessary items for me to make it day to day?
Your Honor,
it doesn't seem
objection, that does
feasible
not
that I
appear
would be-
relevant for purposes of
It
whether or
wouldn't
not the bond
seem-
has been violated in this matter.
And sustained, plus that's more an
It would-
issue for your social security case than your criminal case.
Well, and I think that, Your Honor, if Kristen, if you could, in order to minimize contact, I think that if there would be, a minimum amount on the debit card that she could use, then she wouldn't need to contact her mother to request additional funds, is I think what her point was as far as limiting contact. Again, the issue is that the situation is one where, typically speaking, there would be expected frequent and regular contact between the two of them. And since that's not going to be possible, based on the state's conditions that they're requesting, we're trying to ascertain if there's ways to alleviate those issues in advance instead of, again, setting her up for failure going forward. So
Ms. Randers, I'm gonna let you, or as her attorney, and or her attorney in her social security case to work those details out.
Yes,
I'm
Your
gonna
Honor.
just leave it this simple. If she goes over there and she starts having trouble with her mom again, it's a violation of her bond and she can just sit in jail.
Yes, Your Honor.
Mentally ill or not. So that's my order. Ms. Huerta, you're kind of on thin ice, as the expression goes. You better be nice around your mother, and you better go through your attorney when you need to talk to your mother.
Okay, would it be acceptable that I have a third party, such as a friend, call her whenever I do need funds if I can't get a hold of the attorney to do so for food and stuff? 'Cause I have like no food in my house right now, and
Your Honor,
So,
the
is it
state
acceptable?
would have continuing concerns regarding that. And if the court is going to reserve fully ruling on this motion until the November 3rd hearing, the state will be, it will be over the state's objections noted on the record. The state does respectfully submit that enough evidence has been presented to the court through testimony to rule on the motion, and the state will be objecting to any additional continuances on this issue.
All right, Ms. Huerta, rather than throw you in jail right now, I'm gonna give you a chance, see how you do. You're kind of on a probation with me to see how you do between now and November 3rd. But you be at that courthouse November 3rd.
Ma'am, I will show up.
And don't you have any more trouble with your mom and dad? As a
Ma'am, yes.
condition- All right, you may go at this time. We'll be in recess.
Your
on
Honor.
And
Your
yes,
Honor.
your objection is noted. Who's that, Mr. Bauer?
Thank you, Your Honor.
Yes. Before you conclude this case, I would like to address one quick thing.
Go ahead, Mr. Bauer.
On the probation case, she was ordered to report to probation upon release from the jail. She has never reported to me, to our office. So if you could please advise her that she needs to report to us and get a meeting set up directly.
Hey,
What is
okay,
your
was
name,
that
sir?
Was that a condition of her bond, Mr. Bauer?
No.
I don't know that it was on her bond conditions, but you told her in her hearing last month when you set this court hearing that if she did bond to report to our office directly, because I have taken this case over for CSO Lori McManus, who has left our office. But you did advise her to contact our office upon her being released from jail if she made bond, and she has never contacted our office.
Miss Huerta, where are you located right now?
I'm at the Aspen on Broadway. I can call them right now.
You're
What's
in
the
Wichita,
number, sir?
Kansas? You're in Wichita, Kansas?
Yeah, on Broadway.
Well, you're causing a lot of problems for the court, Miss Huerta. You're taking up a lot of time. The court doesn't have to really give on these kind of issues right now. So I'm inclined to just
Sorry,
say.
that's not my, I'm sorry, I'm not, that's not my intention. I'm just trying to make sure at least have money to eat food and stuff like that, because I don't even really have
You
any
better
money to eat
start-
food.
Well, you can eat food in jail. The jail will give you square meals. And that's
Yeah, I
better
know,
than
but I'm saying, like, I haven't been uncivil with her.
I just don't have the time to keep holding your hand through all this. and
I'm not
finding out-
asking, ma'am, I'm gonna do exactly as you deem, as you just ordered me. I'm gonna make sure that I get that done right now. After I get off of here, I'm gonna call MHA so they can send the paperwork so I can get that sent to her so she can have me as a client activated.
Well, you
over
haven't
there.
done what I've told you to yet, so I don't know that I can believe you now.
Well, but we're just still in court. But yes, ma'am, I understand.
Okay, if I may, Your Honor, I know we're taking up a lot of your time, and I duly apologize for that. She always has money on her card in one way or another. The problem is she spends it and wants it to magically reappear on there. Because I put money on her card every day, a reasonable amount, considering she is a meth addict. If she were to have a payee rep through Social Security, she would only be given between $35 and $40 a week. She gets a lot more than that from me. So I'm just rebuting on what she just said, trying to make it out that mommy's trying to starve me is a load of crap.
I'm not making it out that way. I'm just saying that, like, I have to have money every day. And there's days that I do
You
call
do.
you a lot because I do call you a lot sometimes, but that's whenever I need something to eat because there is no money. Whenever I process the transaction, you can even see
Kristen,
the declination.
this-
You can
okay.
see the declination.
All right,
Stop.
okay, Ms. Huerta, you need to get over to the probation department with CSO Tony Bauer today. Find a ride and get over there today.
Your Honor,
Yes.
Your Honor, I am not in the El Dorado office today. I will be there Friday. If she can report to me Friday at 10:30, I will be in the office on Friday over there.
Okay.
All right,
Yes.
Friday
Can
at
I get a
10:30.
number?
But
Can I get a
Ms.
phone number?
Huerta, I am tired.
Okay.
You're not just doing this and having to have all these commotions about it. Do the bond, do what you're supposed to on the bond. If you have any questions about it, contact Mr. Andrews.
Yes, ma'am.
Contact Mr. Bauer. I don't want you having any more trouble with your parents, no more
Yes, ma'am.
contact with them.
Okay,
I
ma'am.
remember in a prior case with you that you've been a long-term problem with threatening your parents and getting in fights with them. So knock it off. You're an adult now. You need to knock it off. And I know part of it is the mental issues. And you need to be in that state security hospital that I ordered some time ago. But they say they don't have beds and that they don't have to take you if they don't have beds. So my hands are legally tied. Otherwise, you'd be have your bond revoked and be in the state security hospital. But
Ma'am, yes.
But if we go through this again the next time in November, I'm not gonna give you this much time. We're just gonna put you in jail. Understood?
Ma'am, I understand you.
All right.
Can I get a phone number or a name for my probation officer, please?
316-322-4153, Mr. Bauer.
Yes, Your Honor. And then if she can just come see me Friday at 11:30 or 10:30, I will be in the office and I can meet with her and we can get all her stuff updated and going.
And that's the El Dorado office.
Correct, Your Honor.
All right, did you hear that, Miss Huerta?
316-322-4183,
4153.
4153.
Yes. And be at
Ma'am,
his
yes.
office, be at his office in the courthouse this Friday at what time? 10 o'clock, you said?
10:30, Your Honor.
10:30. It's an order on
Okay,
your
I
bond. That's a
will-
conditional bond. And quit using the meth. Quit using the
Yes,
meth or you're
ma'am.
gonna be locked up again for that too. That's an issue of your bond, not to use any meth or any
Yes,
other
ma'am.
illegal drugs or alcohol.
Yes, ma'am.
All right, anything else from anyone?
Your Honor, if the court is continuing fully ruling on the motion for the next hearing over the state's objections, the state would have it known on the record that the state will be moving the court to fully order on concerning the motion at the next setting.
Very well.
Thank you, Your Honor.
Thank you, Mr. McGill. We'll be in recess. Everyone on this case.